That would be great if Bongbong Marcos were just a private citizen or maybe even as a senator, which we allowed. But now that he's gunning for the highest position in the land and knowing as how, the history of this nation has been so adversely affected by what his father and his family as a whole has done, does it not bother you that this person could actually win, be president again, and basically neutralize whatever gains may have been made over the last 35 years?
No, on 2 points. Number one, the presumption of innocence applies to all, even to sons of dictators. I have again read the judicial records. There's not been any indictment against Bongbong Marcos. And secondly, of course, we now have sufficient safeguards to prevent a repeat of 1972. No? The 87 Constitution no longer allows any institution to abolish Congress. And the 1987 Constitution now allows the courts and Congress to review both the factual and the legal basis for the declaration of martial law. One criticism leveled against the 87 Constitution now, it is very difficult to exercise an inherent power of the chief executive to suspend both the writ of habeas corpus and the declaration of martial law. But those are sufficient safeguards against the rise of another authoritarian regime.
Well, Attorney, it's true that he was never impleaded in any of the cases, but he was a signatory to several pleadings laying claim to the Swiss bank accounts, which were, in the end, ruled as ill-gotten wealth by the Supreme Court in 2003. He was part of the pleadings. In fact, he even testified before the Sandigan Bayan.
But
at the
he
same
was not
time,
a party.
And just to add to that,
signed as an administrator, a co-administrator of the estate, but he was not impleaded as a party. He was impleaded as an executor of the estate, because an estate has a separate personality of its own, no? Separate and distinct from the deceased, and separate and distinct from the individuals acting as executors.
Yes, sir. But not only that, he was also actively laying claim to the money. Him, his sisters, and Imelda Marcos. At the same time, we're also looking at the 1997 ruling with finality of the Supreme Court, which stated that the Marcos estate owes 23 billion in estate taxes, which was final already and has not yet been paid for. And unfortunately, Bongbong Marcos din po yung estate administrator. So what happens to that ruling?
An estate administrator only administers the estate. There is no ruling that he was in fact the one who amassed the ill-gotten wealth. We do not know who is responsible for the ill-gotten wealth. Perhaps, in fact, it was a ruling of the court that because this comprised part of the Marcos estate, that the money accumulated by the father is ill-gotten. I will accept that. But he was not impleaded as a person responsible for the graft and corruption. He was impleaded as the administrator of the estate. It was not because he was the one who accumulated ill-gotten wealth. That's very clear from the records.
Yes, sir. But that raises the question, what happens to that pending payment that's been there since 1997? That's 23 billion. And if you follow some Bayan's argument, that could go up to 200 billion already. But that's their calculation. I'm just sticking to the 23 billion of the Supreme Court.
I do not know how much the amount is because no one knows with certainty. What I do know was when I was one of the co-authors of the Marcos compensation bill, we distributed a specific amount of money which the Swiss courts determined should belong to the Philippine people. No? So it was an X amount of money, although I have no personal knowledge how much the ill-gotten wealth could be. No? But then again, I'm stressing, being an administrator does not mean you amass the ill-gotten wealth.
Yes, sir. Yes, sir. And I think we should laud you for your role in that law, awarding the money to the victims. But isn't there any discomfort there that you acknowledge that problem, you acknowledge the victims, you acknowledge the ill-gotten wealth, but your principal, well, not your principal, but your standard bearer does not until now?
I cannot attribute the act of another person to another. There is no such thing as guilt by association. I was, in fact, deemed by many as also being guilty by mere association because I was spokesperson to the president. There is absolutely no legal basis. And in fact, in our jurisprudence, when you read in Re Yamashita, One of the grounds by which Yamashita was in fact acquitted on appeal was because the lower courts allowed guilt by association, which the court ruled was contrary to the presumption of innocence and, of course, fair play.